Hello, everyone. Welcome back to another episode of Immigration and Jobs Talk Show. I'm Rajni Bharara. And before I move ahead, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, after this very important disclaimer, welcome back, everyone. You're watching Immigration and Jobs Talk Show. I'm Rajni Bharara, your host, and today we are tackling a topic that's incredibly relevant in the current job market. Tech layoffs hit hard. What H-1Bs should know. Joining me today are two experts who will help us navigate this complex issue. We have Justin Rivera, an experienced associate attorney specializing in immigration, and Jonathan Wasden, a seasoned immigration litigation attorney from Wasden Immigration Litigation. So, without any further ado, let's give them a very warm welcome. So, Justin and John, it has got a nice ring to it, the name of you two. So, thank you so much for being here.
It's good to be with you.
Yeah, thank you very much for having us.
Thank you so much. And to our lovely audiences, I would like to say that we are live on YouTube, LinkedIn, Facebook, and also, I guess, on Twitter. And the handle is Immigration Talk Show. So don't forget to subscribe to us. And yes, if you have any question related to this topic, you are more than welcome to ask your question in the comments. So keep posting your questions in the comments below. And without any further ado, let's take our very first question. So, Justin, I would like to start the show with you, and I would like to ask my very first question to you, and then we will go into the legal aspects, and then I'll come to you, John. But Justin, let me talk to you first about the 60-day grace period. So let's start by understanding what happens immediately after a layoff for H-1B workers. So if you can please explain the 60-day grace period for H-1B visa holders after a layoff, and one by one, if you can please answer this.
Sure. So the 60-day grace period is, in essence, an opportunity for someone who has suffered a job loss that is on H-1B to do one of three things. So they can either find a new H-1B employer, they can file a change of status to another non-immigrant status, say, for example, F1 or maybe B2, or they can depart the United States. So that's the purpose and intent of the grace period. Again, it is 60 days. That 60 days, I think a common question is, when does that 60 days begin? So it should count from the cessation of employment. So what that means is basically from the time you are actually laid off from the employer, that's going to be the start date of your 60-day grace period. And the reason for that is you're no longer following the H-1B petition because you're no longer employed with that entity that sponsored your H-1B. So that's going to kind of start your countdown clock. Just to kind of give some general information about the grace period and how it applies to the H-1B, while you do have 60 days, if you are looking to change employers to another H-1B employer, remember that petitioner is going to need to go through all of the steps of filing an H-1B for you. So that's going to include filing and posting the labor condition application, the LCA, and then going through the process of putting together the petition, working with the employer, likely the attorney and yourself. And then once you get that certified LCA, submitting it and making sure that it's received by USCIS within the time frame. So a lot of times I like to tell people, while the grace period is a 60-day grace period, if you're trying to move H-1B employers, maybe think of it closer to 50, because you do want to make sure that you leave enough time for you to timely file that H-1B change of employer.
Right, but how many times can this grace period be utilized? Because you have talked about if an employee wants to change its employer, so how many times can this grace period be utilized?
So the way that the grace period works is you kind of just get one bite at the apple. The whole purpose of the grace period is to give you an opportunity to move employers or change status or depart the United States within that timeline. So what I mean by that is, say, hypothetically, you file a transfer in the grace period and that transfer is pending, and then later on you file another transfer. Now, it's possible USCIS is going to see that second transfer as a filing that has already gone outside the grace period because you filed with that first employer. So my recommendation would be make sure that you know the action that you're taking within the grace period before you take it. So ensure that you are done with that decision, that you know for a fact you're going with this employer, or let's say you're going to file a change of status to B2 or a change of status to F1. So you need to be very very certain of what you're doing when you make that decision within the grace period.
Right. I mean, that's something that's really, really important. With that, I also would like to know from you, Justin, that, are there also any other circumstances under which this grace period could be extended, or is it strictly limited to 60 days?
No, you're really kind of stuck within that 60-day time frame that you've been provided to make a determination on what you're going to do. I mean, and that's kind of the whole point of the cessation, the grace period, is when you have that cessation of employment, it's a safety net, right? It gives you something to where you're not going to be out of status immediately or accruing unlawful presence. And the reason that it was put into place is to make sure that you do have that timeline to move along. Now, kind of speaking from a strategy perspective, there is kind of a way that you can extend your period in the United States to look for an employer, and that would be filing a B2 change of status. So let's say hypothetically you are moving, you're not able to find an employer within the grace period. And as a result, you file a change of status to B2. Then let's say that B2 is pending adjudication, and a couple months go by and you find an H-1B employer who is willing to your H-1. There is a situation where, without getting into too many specifics, you can attempt to file basically a change of status back to H-1B and request that the B2 be adjudicated in tandem with the H-1B change of employer. I would also recommend that you would have to do that in premium processing. So again, I know that was a lot of specifics thrown out there, but that is kind of an option for someone who's trying to extend their period in the United States. Now, the thing about that is the B2 is not giving you work authorization. So while you're able to legally remain in the US, you're not going to be able to work. So that's something that you have to factor in as well. But it's a way to sort of extend your timeline in the United States to look for an employer if you need to.
Right. Thank you so much for answering the question, Justin. John, now we would like to switch gears to the legal side a bit. So now I would like to know from you, what legal avenues are available for H-1B workers, who believe that their layoff was maybe unjust or discriminatory?
So when it comes to employment in the US, most states have kind of moved towards an employment at will model. And that means that the employer can fire you at any time for no cause, and there's really no recourse. It gets even more tenuous if you're an H-1B holder, because once you lose your status, then you're unemployable. And if the employer withdraws the petition or informs DHS that you've been terminated, that's it. There's nothing you can do. So your legal recourse against an employer for firing you is very, very limited. And so you really have to, look out for yourself and find ways to find a new job on time, or, alternate arrangements.
Right. But is there any example maybe where the H-1B worker was successfully, pursued legal action after a layoff?
So not really, not that I'm aware of.
Okay.
I haven't ever heard of that working out. I think there's so many, legal hurdles to that. I don't, maybe Justin's heard of something, but I haven't heard of anything that has ever worked out that way.
Okay. Justin, what about you? Have you heard of a case like this?
No, not really. I mean, the only thing that I could possibly think of would be if someone wasn't paid wages that they were owed, prior to their termination. Because then they would no longer be complying with the H-1B. That's something that the employer the employee could report, and then they could open up an investigation as a result. But that would be kind of the only avenue I could think of. So I mean, because obviously even when you're laid off, you're still going to be entitled to the money that you earned while you were there for the hours worked. But outside of that, I'm in agreement with John. There's not a whole lot of recourse for them.
Yeah, and if they're going to go that route with the Department of Labor, it's important that you realize what your timelines are for filing a complaint with the Department of Labor. You have to do it within a year. And if you don't do it within a year, your chances to regain that money is gone. The other thing, to consider is if you've been working without pay, or you've been employed by that company without pay, and you're owed back pay, cooperating with DOL may help you if you file like a T visa for labor trafficking victims. So those are some things to consider when you're in that situation. You got a year, and if you're cooperating, you may make yourself eligible for another type of visa.
Okay. And what if, during that 60-day grace period, if the person gets arrested, then what should the person do, or what are the next steps?
If they get arrested, as in like a DUI or something, that's always a bad situation to be in. I guess it really would depend on what type of crime it is. If it's something where there's significant exposure to jail time, I would say if you still have your passport, go home. But otherwise, I think it might come up in an RFE, but typically not so much. I don't know. What's your experience, Justin?
I haven't, not for non-immigrant visas. I usually haven't seen it come up in an RFE. Where I do see that kind of become an issue is going to be at the consulate.
Yeah.
So if when you're going to get a visa, a new visa, and you're undergoing your interview, there's questions related to that in the DS-160. And obviously those need to be answered truthfully. And as a result, it's probably it's gonna come up, and you could end up getting a denial as a result.
Okay.
Yeah. Justin's point about answering it truthfully is very important, because you got to keep in mind that all of the data with all these federal government and state law enforcement, systems are connected, and most of it is done on biometrics now. And so it's very easy to link up and aggregate information about a particular individual. And then that gets input into the consular consolidated database. And so the first thing that's going to happen when you go to the consulate is that database pops up. And if you've got a flag for whatever reason, they're going to know. They're more than likely going to know before you show up that there is, an arrest out there. So failure to disclose something on the DS-160 like that is really going to be the kiss of death for your immigration future, I think.
Okay. All right. We have also started getting questions from the viewers. So a lot of people have started asking their questions. So in between, I also would like to take the questions from the viewers. So if you would allow, I would like to take questions from the viewers. Is that okay, John and Justin?
Yeah, that's great.
Sure.
Okay. So Madhvi is here, and then RK is here. Benisha is here. Hi, guys. I hope you're doing well. Let's take RK's question. RK says, what impact will the increased registration fee next year have on the H-1B program, as the program has become very expensive between filing fees, extension, etc.? Who would like to take this?
So we probably both have different perspectives on this.
Sure.
Mine is more of an economic issue, which is when you drive up cost, you decrease demand. And USCIS has jacked up fees so much that they're really, cutting into any type of profit margin people have for hiring a foreign worker. So, companies that are used to transitioning employees in and out frequently are not going to be very profitable because of these increased fees, and will probably file fewer petitions going forward, would be my guess.
What about you, Justin?
I agree with John. I definitely think that unfortunately the increased fees are going to have they're going to be most harmful to smaller companies. Unfortunately, I think the bigger organizations that just have the bigger war chest, that have more money to throw around, I don't think they're going to be as worried about the increases. But I do think it's going to give pause to smaller companies that are looking to hire foreign nationals, just because it's a big investment. I mean, you do have the increase that's also going in to the lottery next year for registrations too. And I think right now we've been dealing with such a low entry point for that fee that it was very easy to say, all right, whatever, it's nothing. It's $10 a person. Let's throw this person in. If they get selected, great. We'll figure it out. Raising it now, I think you are going to see employers probably pausing a little bit and digging a little bit more into how viable it is to register the individual. I could tell you from experience that I was working with a company last year that had a couple people who got selected that they just didn't file for because they never really even bothered into looking into their status or seeing, what it was going to be for them to change status or what steps they would need to take. And as a result, they ended up not filing for them. Now, when you're just eating $10, that's not that big of a deal. When you're eating more money, I think, there's more of a consideration. And then, like John said, the fees have been continuously raised to where you are really making a financial investment filing for an individual. So I think, taking both of those together, you might see less people filing as a result.
Yeah. And maybe then, people won't be expecting people because there will be less chances, and there won't be too many people waiting for a second lottery or the third lottery, right? So, in the second lottery, I think some 14,000 have something around 14,000 people have been selected in the second lottery, but still there are a lot of people. 14,534 to be exact. But there are still a lot of them, who must be waiting to still get selected. Do you think we still have an option for a third round? What do you have to say, John? Can they be hopeful?
I think the third round, it comes down to an issue of timing because they've got to wrap this up by September 30th. And knowing how slow USCIS does everything, that would be a real challenge for them to get a third lottery in. Right.
Justin, what about you? What do you think?
Yeah, I agree. And I think that's kind of echoed by the window for the filing period that they gave on the selection notices, which run, if I remember right, all the way into November. I can't see them because they're going to wait for everything to conclude because everyone has that window to file that 90-day period. And then only after that time would they really be able to kind of look and make a determination of whether or not they have more spots available. Like John said, with the way the government works, how slowly they operate, I don't think it's realistic to expect there to be a third lottery.
Wow. Okay. I'm sure a lot of people will get disheartened after hearing this, but if that's the truth, I mean,
I would love to be wrong. I would love to be wrong.
Right. Okay. And RK also has one more question. He says, do you see more employers just saying it's cheaper to just poach workers rather than spending thousands of dollars to register for the lottery? What do you think, John?
So I think when it comes to the consultancy companies, you look at the way their business model works, and there's a lot of turnover, and that drives costs on petitions. So poaching employees doesn't really save you a whole lot of money. You're still having to pay filing fees. You're still having to pay, lawyer fees for petitions. And so the people that are in the smaller businesses, like Justin mentioned, tend to have bigger turnover, and their costs are going to be higher. And my guess is you'll see a decline in their filings, and you'll also see a decline in revenue that USCIS collects. And the grand irony of this is, if I'm right, and they do lose a lot of revenue because of the cost, because of the supply and demand, USCIS is going to have a bigger budget shortfall than they already do, because they've started hiring in anticipation of these new fees being collected at the same rate as the old fees. And when that doesn't pan out, there's going to be, a huge gap in their budget. So it remains to be seen how effective this new fee increase is going to be.
Okay. And we have one more question, and this question is from Maria, and she says, I heard in a video that employers can only file petition one H-1B employee. Is that true? Justin, do you think it's true?
So typically when you're filing an H-1B, you're going to be sponsoring one beneficiary. Or is the question asking something else? Are they asking if you can only file as the petitioner for one individual? I'm a bit confused.
I think that employees can only, yeah, it seems a bit general. I heard in a video that employees can only file petition one H-1B employee. Right. Even now, I'm trying to understand the question whether it's talking about one employer or
Yeah,
one.
I guess if we're talking about the lottery, then no, because the petitioner is able to file for, however many selected individuals they have. Now, if they are saying, can they only file for the employee that has been selected in the registration notice? That is correct. You can only file for the individual that actually has the selection notice with their information on it. So in that circumstance, yes, you can only file for that person. You cannot transfer a selection notice, meaning you can't use it for somebody else. And it works the same way for the petitioner. You can't have a different employer sponsor you just because you were selected by employer A. So you can't just move over to employer B to have them file your H-1B in the event that A no longer has a position available for you. I hope that answers the question.
Yeah, it does. It does. But John, would you like to add something to it?
No, I think Justin covered that pretty well.
All right. Okay. So, Maria, I hope you have got the answer, and let us know if you would like to know something else, or maybe you can rephrase your question if you meant something else, so that Justin can maybe give a proper answer to your question. And now,
I did want to say just real quick, if I could, about the whole poaching employers versus filing in the lottery. I think John made great points on that, and I did want to add too. I will say that, when you get a new H-1B employer, you do have them for 6 years, or at least they have 6 years on that H-1B. And obviously you can go through the PERM process and get an I-140 that allows you to continue extending. A new employer that's just starting that first year of H-1B has different considerations than someone who's maybe in their 4th or 5th year on an H-1. So, if they're in their 4th or 5th year and they haven't started the PERM process, or they don't have that approved I-140, that's something an employer is going to, or at least should take into consideration when they're looking to transfer the employee. So I would definitely say that there's going to be employers that think it's better to just have that new employer on an H-1B. Rather than going to look for someone else that's going to carry all the hiccups of maybe needing to extend beyond 6 years.
Okay. All right. Thank you so much again for answering the question, Justin. And again, I would like to come to you, and I would like to come back to my own questions again. Then of course, in some time, I will again move to the audience's question. But right now, I would again like to ask from you that once an H-1B worker is laid off, so what should be the immediate steps that they should take to maintain their legal status in the US?
Okay. So yeah, I think that it's going to be determined based on whether or not, first off, I think the best situation for pretty much anyone's going to be, can you move to another employer on an H-1B and continue your H-1B? Because that's going to be the easiest part, the easiest way. It's the most straightforward way to deal with the situation. So after you unfortunately lose your job, I would say immediately begin reaching out or using a recruiter or taking those steps to begin finding another avenue of employment. As we talked about at the beginning of the call, it is a 60-day grace period, but for that H-1B, it's actually a shorter timeline because you got to make sure that the case is filed and received by USCIS. So that would be my first option. My best course of action would be that. Second option is going to probably be changing status. That could be maybe if you decide to file a change of status to F1, maybe you're able to pursue a second master's or your first master's degree in the United States, based on if you were selected with a bachelor's degree only. So that would be option number 2. Again, you want to make sure that that's filed and received by USCIS within the grace period. Option 3, and probably the option people don't want to hear, is going to be just departing the United States. Now, while that's not an ideal situation for anyone, you can think about it like this. Just because you're leaving the U.S. doesn't mean you can't have someone sponsor you for a new H-1B. They'll just have to file a consular notification or consular processing. So that is still something that you could explore. Now, I do put it at the bottom of the options because I think it's the one people least want to pursue. But it is something that's on the table. So I would definitely say in tiers, tier 1, getting a transfer to another H-1B employer. Tier 2, filing that change of status. Maybe you file a change of status to B2 to buy yourself some more time to find a new employer for your H-1B transfer. And then you have to go through that strategy of filing the change of employer, the change status back to H-1B and premium. And then tier 3, maybe having to depart the U.S. and wait until you can find a new employer to sponsor your H-1B consular notification.
Okay. And John, in your experience, how quickly do most laid off workers find new employment, and what do you think are the most challenges do they typically face in the job market?
So I think it's really just dependent on the economy at the time they get laid off. Usually, when there's layoffs, that's usually a bad indicator for the broader economy. It's going to be harder to find jobs because most employers are pulling back. So, it's going to be a challenge for people, I think, in the tech industry to find new jobs in the short term until the economy starts to improve a little bit. So I wouldn't be surprised if there's a lot of people who hit that 60-day window and end up losing their status.
Okay. And what do you think? What happens to H-4 EAD if someone gets laid off?
Then nothing. I mean, they're totally fine. That's the best case scenario of all of these options. That's the best case scenario. If you're an H-4 and you have an EAD and you get laid off, you have all the time in the world to find a new job, and there's no problem with your status, and there's no problem with your EAD because it's not tied to the employer.
Okay. Justin, would you like to add something to it?
No, it's just, for whatever reason, the H-4 EAD, it seems like a better deal than the H-1B. But yeah, John's right. You get laid off, no problem. There's no work requirement for the H-4 EAD. Right. So you got plenty of time to find a new job as long as the principal, the H-1B holders, is remaining in status, you're fine.
Okay, and we have one question, which is here on LinkedIn, and the question is from Abbas. And he says, after 6 years of H-1B, what are the extension options? Who would like to take it, John or Justin?
So I can take a high level. Justin might have some more in depth, but sure. You don't have a lot of options. If you don't have an I-140 or a immigrant visa in progress, then you don't have any extension beyond the 6 years available to you. So you've either got to leave the country, find a new visa status, or go back into the H-1 lottery again and get a new H-1 that allows you another 6 years. Did I miss anything there, Justin?
No, that's it, really. I mean, there's a very narrow, caveated situation where you could have a PERM that was filed before your 6th year. So you got to file it basically a full year before you max out. And then if it's still pending for whatever reason after your 6th year, at the 6-year expiration point, you can apply for a 1-year extension. And that's really the only other option that you have. And that's very nuanced and specific. It requires, you have to strategize that. I mean, really with your attorney, because you've got to be filing right. I mean, if not right at, then well before that 365-day period before the 6th year hits. But outside of those circumstances, it's like John said. I mean, that's really your only options.
Okay. All right. So Abbas, I hope you have got the answer. Thank you so much for your question. Let us know if you have another one. John, I would like to come back to you again, and I would like to know from you that have you noticed any trends in litigation related to layoffs in the tech sector, particularly concerning immigration status?
So I think the biggest trend that was beginning to develop was with something called OCAHO. It's a administrative court system that the Justice Department runs for claims of discrimination based on immigration status and employment. And there's these, advocates for the tech industry that file a bunch of very specious claims with OCAHO. they're not really looking for employment, but they just go onto all these job websites and they apply for all these jobs. And when they don't get selected, they claim it's because they're preferring immigrants, and so then they're suing within OCAHO. That was a trend until OCAHO got shut down recently by a federal court because it has some legal problems with the way that it's structured. So depending on how that works out and how that's resolved, that issue may come back or it may go away entirely.
Okay, and what implication do these trends have, in terms of compliance and risk management?
So for the OCAHO cases, it's frustrating because you can comply with all of the Department of Labor's rules for recruitment, and you can do everything right according to the book, but still make out an OCAHO complaint that makes the employer liable. So it's very frustrating because you're kind of in this gray area. Even you're damned if you do, you're damned if you don't. You can follow all the rules and still have to pay a hefty penalty to the government for it. So it's one of the more frustrating areas of immigration law right now.
Okay. All right. Thank you so much for answering the question again, John. And RK is back, and he says, what happens to the H-4 EAD if the spouse on why am I not able to display it on screen? Let me, okay, here it is. What happens to the H-4 EAD if the spouse on H-1B gets layoff for which your H-4 is dependent on? Dustin, would you like to take it?
Yeah, I think that's a difficult spot. I think that it's unfortunately a difficult spot because the H-4 is dependent on the H-1B. So as a result, you're not immediately impacted by the layoff. What I mean by that is the EAD doesn't just go away, and there's not any issue with the H-4 holders failing to maintain status during that period. The problem becomes, if the H-1B holder is not able to transfer to another status, or if the H-1B holder has to change status, then you get into a situation where the primary is no longer maintaining their H-1B status, which that H-4 is dependent on. So I think you get into a bit of a gray area situation there where you're saying, well, is the H-4 going to still be valid as a result? And as a result, will the EAD be valid as well? I think that's kind of going into a little bit more detail than my thought process would be, and John can tell me if he agrees or if he differs. My thought process would be if you're changing status, then arguably until the change of status goes into effect, there's not anything happening to the H-4 itself. But once that primary does change status, if they move to B2 or F1, then you can no longer hold H-4 status because it's dependent on the primary. So that would be my thought. And then as a result, once you're no longer able to be an H-4, you can't utilize the EAD. I don't know if John sees it differently or if he thinks the impact of just filing the change of status would impact them.
So it's one of those areas that USCIS has never given any guidance to the public on. And a lot of times when they do that, they can enforce it both ways if they want to, because there's really no rule that says they can't do something, and there's no rule that says what they have to do. I think in this situation, if both arguments are probably equally as strong, whether or not the status and the EAD terminate at the end of the 60th day, or whether or not they're good until there's an adjudication on the change of status petition. We just don't know how USCIS will answer that question in any given particular situation. So if you're worried about it, caution is always the best thing to do when it comes to your immigration status. So talk to an attorney just to make sure you're not going to jam yourself up.
Right. Mm-hmm. And I do think that, the H-4 EAD itself, I don't think is really it's not going to go away. I don't think just because the H-1B holder loses their job. But the issue kind of for me becomes, are you maintaining your H-4 status if your primary has already filed a change of status to move into another status, because they're no longer in H-1B. They're not holding it. They're in the United States because they timely filed a change of status to another status. So I'm not sure if that means does USCIS actually make an action or a move to invalidate the underlying H-4 status or the EAD. I'm not sure. I haven't seen that specifically, but I do think John makes a great point. You kind of preach caution. You don't want to be violating your status. So yeah, I would just be careful about that, and hopefully you're not dealing with that situation because the H-1B holder is able to find another employer.
Right. And he's also back with another question. So he says, after max out, do you re-enter the lottery? I thought you just had to stay outside the country for 1 year before returning without needing to re-enter the lottery. What do you have to say, Justin?
Oh man, I think if I remember right, and maybe not. I don't know if did I say that? I think if I remember right, that you can still remain cap exempt if you leave for a year. I'm pretty sure. I haven't encountered that question, so maybe in a while. So maybe don't take my word for it. But I do think it is possible where you can stay out for a year. But I'm so sorry. I can't remember that right now.
John, what do you think? I mean, have you encountered that question?
So, statutorily, unless there's something in the regulations that I'm missing, statutorily, you're capped at 6 years for the H-1B. So there may be some ambiguity in the statute that the agency's exploited to create an exception. I just don't know off the top of my head. I'd have to look into that.
And if you're thinking about a situation where you don't utilize all 6 years of the H-1B and then you depart the United States and stay outside for a year, is that maybe more an option that you're talking about exploring? Because if you completely max out, I'm pretty sure, if I remember correctly, that you're going to have to go back into the lottery.
You can do recapture, right? You can
right.
So that's probably the option that you've got, is go through your pay stubs, go through your travel history, and see when you were not working in the U.S. Try and do recapture. You've got a little bit of time to play with.
Mm-hmm.
Okay. And let's say if the H-1B worker cannot find a job within the grace period, so what options do they have to change their status?
If you're not able to find a new job, you can move to another non-immigrant status. I would definitely say the B2 option is going to be there for you because it's a visitor visa. It gives
you cannot work on that visa, right?
No, you're not given any work authorization on that. You get it's 6 months, and it can be subject to an extension. But it allows you to remain in the United States. Now, the other option is going to be an F1. If you move to F1 status, then you have maybe potentially the option to work, depending on what your school situation is and what type of degree you're pursuing. Maybe you're able to do CPT or something like that. Then I would also say, kind of just thinking off the top of my head, a great situation would definitely be, if your spouse is an H-1B holder, or maybe an L1 holder, maybe they have a visa that allows you to change status to H-4 or L2, which would give you about an opportunity to get work authorization. Now, for the L2, if I remember correctly, your work authorization is going to be incident to status. So that would be a situation where you could just change status and start working immediately. Whereas the H-4, you are going to need your spouse to have that approved I-140 in order for you to apply for the EAD. So, it would depend, but that's still going to give you a better situation likely than if you're going to be transferring to a B2 or an F1. That being said, as I kind of talked about a little bit earlier, you do have that option with the B2 to kind of use it as a bit of an extension period to find another employer. And then you can maybe hopefully find an H-1B employer who's willing to sponsor you, and then file that change of status in premium back to H-1B. Typically, when I had done those cases in the past, what I would do is just ask USCIS if the B2 is not adjudicated to adjudicate both cases in tandem. So meaning at the same time. So you would basically put a note or a cover letter or something just saying, B2 is pending for this individual. They're legally in the United States. In order for them to move back to H-1B, we ask at this time that USCIS adjudicate the B2 and then the H-1B so that the individual can be put into H-1B status and continue working with employer X.
Okay. Thank you so much for answering the question again, Justin. John, I would like to come to you. Are there any particular visa categories that are more accessible for laid off H-1B workers? And if yes, what is the application process like?
So like Justin says, the B2 and the F1 are probably the most common that we see people transition into. Yeah, if you're doing an F1, just, my advice is to always try and go to one level higher of education if you can, instead of just getting a lateral degree. USCIS tends to be suspicious of the lateral degrees, the second degree. So those are your two best options at this point, I think, unless you're married to, like Justin says, an L1 or an H1, and then you've got those options available to you to transition to a dependent spouse visa. And the L2 is a great one because you have work incident to status, and it didn't used to be that way. It used to be USCIS made people pay for application fees and wait 6 to 7 months for a EAD card. But after losing that issue in court, now it's just incident to status. So if you have an L2, you can work.
Right. And we are still getting a lot of questions from our viewers, and Abbas is actually back. He says, if the PERM is in process and you are past the 365 days, even if your 6 years of the H-1B are done, you are still in status? Justin, would you like to take that?
I think this might be kind of piggybacking on what I was saying earlier, and I don't think that it's kind of understanding what I was trying to say. So what I was trying to explain was there's a very specific situation where if you file, if your PERM is filed 365 days before you reach 6 years. So what that means is one year before your max out date, and it is still pending before your 6 years maxes, then you are eligible for 1 year of an extension of your H-1B. So what that means is you can file for a 1 year extension with the understanding that 1 year is going to allow the PERM process to conclude, or for you to file your I-140 after it's approved. That's kind of the specifics of what I was trying to talk about earlier.
Okay. And we have one more question. And this question is from a LinkedIn user. We don't see a name here, but the question is, if my H-1B got approved, but my employer is not allowing me for stamping, is there any chance to transfer my H-1? Do I have to file entire H-1B petition or only LCA is fine? John, would you like to take this?
Actually, that's probably an area that Justin's more of an expert than me. So I'll defer to him on that.
Sure. Yeah, I got you. My H-1's approved and the employer is not allowing me to go for stamping. Can I still transfer my H-1? Do I have to file the entire H-1B petition? Yeah. So if you're changing employers, you have to file a petition. It's not sufficient to just file an LCA. So if you're in a situation where your employer is not allowing you to go for visa stamping, and I guess maybe because they're going to get rid of your position if you depart the U.S. for an extensive period of time, and you want to transfer your H-1, you can do that. But it's not sufficient to just file a labor condition application with the new employer. You need to file a new H-1B. And I would also go as far as to say, wait for the H-1B to be approved before you're traveling. And since it's not a change of status, it's not going to be denied just because you've departed the U.S. But I do think you want to stay in and make sure that case gets approved before you go abroad and try to get a visa stamp, just in the event that maybe you get an RFE that draws the case out, or maybe in the event that you end up, unfortunately, getting a denial and you have to remain with that first employer.
Okay. All right. So the name is Yashwant actually, but we can't see the name here. So Yashwant, I hope you have got the answer. Thank you so much for your question. We're still getting a lot of questions. Let me quickly take other questions too. So Hamid is also here, and he says, "Can you talk about EB2 or H-1B?" Well, H-1B is something that we're already talking about. So if you can talk about EB2, so John, would you like to talk a little bit about EB2 as well?
Yeah, I guess which type of EB2, I guess, would be my first question. Is he looking at a national interest waiver or just the advanced degree, professional degree visa? So, the national interest waiver is tough to get, but it is highly sought after, I think, by a lot of people, just because it avoids a lot of the hassle and the administrative work that has to go into filing a petition. But the EB2, just regular EB2, just requires you to have a master's degree or an advanced degree in order to qualify. So the EB3 professional category requires that you have a 4-year bachelor's degree. So a lot of countries have a 3-year bachelor's degree. USCIS will not accept a baccalaureate degree. They require you to have a 4-year. So they'll take a combination of, say, a 3-year degree and then a 2-year master's degree to qualify for the EB3 professional. But if you want to qualify for the EB2, you've either got to get a new master's degree, or you have to have over 5 years of relevant work experience, and that's progressively developmental in that area in order to qualify as a substitute for the degree. So it's a very high level overview of it, but regular EB2 requires a labor cert, so it takes just as much time as the EB3.
Okay. But Justin, would you like to add something to it?
No, not on the EB2 part. I will say for the H-1B part, because I know we had discussed earlier about the whole issue of maxing out your 6 years. I did want to go ahead and look into it, and it does look like under INA 214G4, it does look like if you do reside and remain physically present outside the U.S. for 1 full year, there is eligibility for a new 6-year period H-1B status that restarts. So I did want to clear that up and look into it. So it does look like if you do max that 6 years out and then you go remain outside the U.S. for a full year abroad, you can restart your 6-year period.
Okay, this is so great. Yeah, even though we are taking questions, the new questions, but you're not forgetting about the old ones. So thank you so much for also doing that.
Yeah, no problem. It just bothered me.
Thank you so much. And John, I would like to again come back to you and talk to you a little bit about how do tech layoffs affect individuals who are in the process of applying for a green card, especially those with pending I-485 applications.
Yeah, that's a very tough situation, because you've got to have that continuing offer of employment, and it's going to be a case-by-case situation, but you've got to have a 485J that is backed by a legitimate offer of employment, and getting that in this environment might be a little tough, but it's what you've got to do. Justin, you got a different take on that?
So I think the people who are in the process with the 485 applications, they're in a tough spot. I think the people who are really just out of luck are people that are going through PERM. Because if you're in the PERM process, you're maybe going through recruitment or something like that, and you get laid off, there's no recourse. It's done. You don't have an opportunity to move forward. And you're not going to be able to, go through with PERM and then get to the I-140 process. Now, if you have an approved I-140 and your I-140 has been pending, has remained with the employer, I believe it's 180 days, then I believe you can end up transferring over that I-140 in the future, so you can maintain that benefit. But I think the people who are most most affected by it are going to be people that are going through PERM. I actually saw that, unfortunately, in my prior position, where you just had recruitment cease on all these people that were undergoing layoffs. And, these people are under the belief that, their H-1Bs maybe in its second or third year. They have plenty of time to go in and have everything set up to where they can get their I-140 approved. And if they're from a country where they have to wait a while, they at least have the ability to continue extending that H-1B. And then that's all gone because they're laid off. So it's kind of like you're dealing with two problems. Not only are you dealing with the problem that, you have to look for an H-1B employer, but then you turn around and have to consider, oh, great, now I have to restart this entire process, which it's a long process. I mean, the prevailing wage determination alone right now is taking between, I think, 3 to 5 months. Mm-hmm. So, I do feel bad for people that are dealing with that. I definitely would say your priority one should obviously be trying to move employers just so you can maintain your H-1B. But then once that happens, I think priority two is saying, hey, if you don't have that I-140, we got to get moving on PERM. So yeah, that would just kind of be my input. Is it's a tough situation to be in for multiple reasons. And that's why I think when you're having a conversation, with your attorney or whoever you're working with during the transfer process, I think that's definitely something you should bring up, or at least make everyone involved aware of, your employer as well. Like, hey, my 6-year max is X, and what are we going to do to address that?
Okay, so any advice would you like to give to those in the middle of their green card process who are now facing uncertainty due to layoff, maybe?
I don't really have, John, if you have anything. I mean, it's just hope your employer is going to keep sponsoring that position, but I don't know.
John, what advice do you have for them?
No pearls of wisdom on that one. That's a tough spot. It really is.
Mm-hmm. All right. Okay. So I think we still have a few questions from our viewers, so let me quickly take them as well. And then I have a separate question actually for the both of you, so I will take that towards the end. So Benisha is also here, and she says, I'm facing a layoff and considering transitioning to another visa category such as O1 or F1. What guidance can you offer, and what are the key considerations for each option? John, would you like to take this?
So for the F1, it requires you to pay for tuition. That's expensive. I honestly don't understand how people do it. You're unemployable many times on the F1, and you're having to pay a god-awful amount of money for tuition. Just seems like it's a tough time. The O1, much cheaper, but your standards are quite a bit higher. If you're, depending on where you're working, what field you're in, if you're in AI, great. Your odds of getting an O1 have just been dramatically increased by the Biden administration. But O1s are one of those kind of weird areas of law where the standards are so vague that it really is just in the eye of the beholder of the individual adjudicator. And when the frustrating thing is, and this was frustrating to me when I was watching it happen when I worked for USCIS, is that you have people that can barely turn on their computer, that can't map themselves to a printer. And they're making these decisions on these O1s and whether or not, they're really outstanding and whether or not they're, head and shoulders above their peers in their abilities, when they really don't have any clue what you do. So that's the frustration with the O1, is that it's kind of like art. It's in the eye of the beholder, and the only beholder that matters is that individual adjudicator.
Okay. So Justin, would you like to add something?
Yeah, I would say that for the O1, I've done a few of them, and like John said, I mean, you're looking at a pretty high bar. It's a lot. Evidentiary, you're looking at a lot that needs to be supplied, and then you're kind of having to be a teacher as the attorney, because the adjudicators don't understand what these people do. So not only are you trying to explain what this person does and what makes them prestigious, you're also having to basically spoon feed that officer an understanding, or at least a layman terms understanding of what this person is and what they bring to the table. Now, it's easier to do that when you can show awards, things like, he placed in this competition or he received this distinguished award. That helps, but that's not always an easy thing to do. So it really it really turns on, the ability of the attorney to interpret the information provided by the employee and just how much data really the employee can put together to be used. I will say that, I've done some unique O1s that were approved that were for, people in marketing positions that had just, they had worked at prestigious companies and they'd received a lot of accolades as a result. And that we were able to successfully adjudicate those get those adjudicated without issue. And then I've also done one for tech people who seemed extremely prestigious. They had a lot of, research papers and things like that made them very distinguished. And we ended up getting RFEs on those. Whereas I kind of thought, oh, these people seem so clear cut. I can't believe that it would even merit an RFE. But I do think it kind of goes back to what John says. It's up to that officer really to make that determination. And we don't know who that officer is or how much they understand about, like John said, for example, artificial intelligence. So yeah, I would just say, between the two, the O1's going to be the much higher burden, the much higher evidentiary requirement, and it's going to be the much more difficult petition to put together. I would definitely say you need to talk to an immigration attorney before you try to consider an O1. I would never ever consider filing something like that on your own.
Okay. So, Benisha, I hope you've got the answer. You've got the answer actually from both of them, from John and Justin. So, thank you so much for your question. And John and Justin, before I let you go, there's one case that we got on WhatsApp. So, I would like to read this case for you, and I would like to take both of your opinions on this. So, it says, my mom's green card application I-130 was approved. She's currently in India. So, I filed an I-824 to forward the approval to the NVC for processing at the correct consulate in India for her biometrics appointment. Despite multiple follow-up requests, I haven't received any updates from USCIS. Online case status shows received, but I did not get a mail confirmation. Communication requested status via email was directed to reach out to the lockbox email, but received no response. What steps can I take to expedite this process and get a response from USCIS? John, would you like to take this?
Yeah, so USCIS's mailroom has always been a little bit spotty in their efficiency and their capabilities. They lose mail all the time that they're sending. They lose mail all the time that they're receiving. And it sounds like she's in that situation. USCIS, as frequently as they screw up, will never admit that. And so when you're trying to, fix a USCIS screw up, it's always going to take a lot of work to do that. And so, there's no quick, easy way, because the agency has basically walled themselves off from the public, and there's no engagement with the public, and there's no way to simply or easily resolve a problem. But they are required by law to give you that receipt notice. And the fact that they haven't done it means that they haven't complied with the law. And anytime that happens, when it's clear cut like that, you can file a complaint in court saying, hey, I want my receipt. And you'll probably get it within 60 days because the government has 60 days to respond to a complaint in federal court. And the U.S. Attorney's Office that gets that complaint is going to look at it. And the first thing they're going to do is they're going to call the agency and say, mail this out. I don't want to deal with this case. Make it go away. And you'll get that. I don't know if Justin has an easier way to fix this problem, but
Justin, do you?
I mean, not really. It seems like she's gone through the avenues that are generally recommended. You could try using Emma, which is like the service that's on USCIS's website, to raise a service request, to explain that you haven't received the notification. That would be one avenue that you could try pursuing. But that would be kind of the only the only real advice that I could give you. It's gonna take time because they're gonna intake it, and then they're gonna say, hey, we're gonna have X amount of days to respond. But that would be my general advice. Would be to try to use that service. I know some people have actually been able to use it recently to get like typographical errors on receipt notices corrected and sent to them. So, I mean, if it's advanced enough to be able to handle a situation like that, maybe it could handle something as simplistic as locating a receipt notice.
And we can only hope that they really incorporate AI into their operations and replace all of their adjudicators.
Okay. On that note, thank you so much, both of you, for coming and doing the show. We always do it with John or either Justin, but having two of you together it made it even better. So thank you so much for your time.
It was good being here.
But
Yeah,
so
thank you
before
so
I let you go, any last message for the ones who are facing layoff? Let's start with Justin. Justin, any last message?
Yeah, I would just say, I know getting laid off is tough. Trust me, I've undergone that experience myself. So I would just say, brush yourself off, get the online resume ready. I would probably try to work with a recruiter to see if you can move into a position, maybe be open to something that you wouldn't traditionally be open to. If it's a drop in salary, it is what it is. I think the primary goal here right now is, ensuring that you're staying in the United States and staying in status. A transfer doesn't mean you're with the employer forever. It just means you're with the employer right now. So that would kind of be my general advice is, look for what you can find it as fast as you can. And I would also say from practice experience, when you're moving to a new employer, you might need to be a little bit of a pain to make sure that case gets timely filed. Because if it's an employer that doesn't hire a lot of H-1B employees, they may not realize how long the time process is or all of the steps that go in to having the H-1B filed. So you might need to be on top of them from the moment that offer letter gets signed until you know that the H-1B has been delivered.
Okay. And what about you, John? What advice do you have?
So this kind of applies to people who haven't been selected in the lottery and are in this situation with layoffs. One thing to keep in mind is that there are cap exempt employers out there, and they tend to be large organizations that run on annual fiscal year budgets that aren't quite as impacted by the sways and the fluctuations of the economy, and provide a lot more stability. The wages tend to be lower, but it does give you additional flexibility. And if you're married to somebody and you have a cap exempt H1, they're an H4 eligible, potentially eligible for an EAD if you have a labor cert in progress. So, that's something to consider. I would look for those cap exempt employers as a potential opportunity.
Okay. Thank you so much again, John and Justin, for doing the show. But we have just received another question from a viewer. So can I please take that if that's okay for you? Before I let you. Okay. So Justin, don't worry. This is going to be the last one.
Oh, no, I'm fine.
Okay. So this question says, can I apply for a B? Okay. Can I apply for a B1 or F1 visa if my H1 has already been approved by my employer, who is not allowing me? I don't know why am I not able to show it here on screen. Okay, here it is. Can I apply for a B1 or F1 visa if my H1 has already been approved by my employer, who is not allowing me to go for an interview? If I apply for a B1 with same employer or F1 again, will there be any issues regarding being considered a potential immigrant?
Okay. Trying to be as nice as possible. This question's a little all over the place. If your H-1B has already been approved by your employer and they're not letting you go for an interview, I'm assuming that means they're not letting them go for a visa interview abroad. If I apply for a B1 with the same employer, you don't apply for a B1 with an employer. That's a a business visa or a visitor visa, like a tourist visa, right? A B1 or an F1. An F1's definitely not employer specific. Will there be any issues? Potential immigrant. So I'm guessing this whole question kind of is that they're asking about immigrant intent. The worry about immigrant intent if they switch between an H-1B and an F1 or a B1. Is that what's being asked?
Okay, so Yashwant, if you can please clarify, because yeah, B1 and F1, you don't need an employer to. That's right. But with whatever that you can understand, do you have an answer, or maybe John, do you have an answer with whatever that you can understand from this question?
Well, they're all non-immigrant visa categories.
Yeah.
So I don't really see anything there that would impact the immigrant intent issue. Immigrant intent is usually when you have an application for an immigrant visa and you're trying to come in on a non-immigrant visa that is not a dual intent visa, then there's issues there in terms of establishing your non-immigrant intent. But where all of these are non-immigrant visas, I don't really see that being an issue.
Okay. Right.
Yeah, I guess too. What's I guess kind of throwing me off about this question, and I think we've seen another question about this too, is this issue that your employer is not letting you go for a visa interview. I'm that's an interesting thing for me to see. I mean, I've definitely seen employers say, "Hey, don't go," during a busy season or a certain period. But I mean, you're gonna be allowed to. You're eligible for vacation. I mean, if it's part of what you were hired on and part of like your employment package. So it seems odd that they would, just be able to block you off from going for visa stamping. If you're traveling abroad and you've scheduled an appointment, you should be able to go. I don't know. It's interesting for me to see that this is a second question about, people having issues where their employers are not letting them go for a visa interview.
Okay, so Yashwant, what you can do is maybe you can directly get in touch with John and Justin, and here are their contact details. The number is 844-592-7336. I would like to repeat the number, 844-592-7336. Their email is support@wasden.law, and you can also check their website out, which is wasden.law. So yes, get in touch with them, everyone, and Yashwant, specifically you, so that you can get a better answer from them. And thank you so much. And if you're looking for a project placement or visa sponsorship, you can reach out to me on my number, which is 732-707-9151. And my email is rajni@higheritpeople.com, and our website is www.higheritpeople.com. So yes, you can also check that out. Remember, we sponsor H-1B visas and other work visas based on job availability and regulations. With that, thank you so much again, John and Justin, for being here. And it was a great episode, and looking forward to our next episode now.
It's good being with you. Thank you.
Yeah, thank you for having us. Have a good day.
Thank you so much. And to our lovely viewers, I hope you enjoyed the episode too. Thank you so much for sending in your questions. We greatly enjoyed, taking them. And I'm sure John and Justin also enjoyed answering their questions. So we have another webinars coming up at 12 and 2. So don't forget to, watch them. So stay tuned with Immigration and Jobs Talk Show. I'm Rajni Bharara. Keep subscribing, keep watching our channel. And yes, if you like our webinars, if you like our videos, so don't forget to like them, share them, and also subscribe to our channel. And right now I'll have to take your leave because in about half an hour, or I think 40 minutes, we have another webinar coming up with immigration attorney Prashanthi Reddy. So don't miss that. And for now, bye, take care, and keep subscribing to Immigration and Jobs Talk Show. Take care.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 732-707-9151 or mail us at Rajni at higheritpeople.com or visit our website